Good evening, all. Welcome to the final session for today's conference. The panelists for today's session are Shri Amit Pradhan. He's the Executive Director of IBBI. And we have Dr. Kokila Jairam. She's DGM at IBBI. Just to set the rules of how things would be happening, we have 3 paper presentations for today. Each paper would be presented for 17 minutes, following which the judges can ask questions for 5 minutes. The first set of presenters that we have today would be presenting a paper titled A Recursive PLS-SEM Approach to Determine Causal Factors of Corporate Bankruptcy in India. It would be presented by Abhishek Haldar, Pratik Nahar, and Shashank Prakash.
Good afternoon to one and all present here. So our study is a recursive PLS-SEM approach to determine what are the causal factors behind the corporate bankruptcy trend in India. For the last 5 years, we have seen the IBC has been implemented, and I first explain what has been the motivation and the context behind this study. So we started from corporate distress. So we have a study based in 2015 from the Vienna University and the Swiss Finance Institute, which talks about the extent of corporate distress being defined by 3 factors, which are the macroprudential regulation on bank lending, the microprudential policies of credit quality, and the debtor-specific characteristics. So these 3 are very important from a point of view of the financial stability, and as we talk in finance about the systematic risk and the idiosyncratic risk of the firm as well. And there is a IMF 2010 paper, it is a staff position note which tells that insolvency related legal processes are necessary for the entire bankruptcy regulation in India, but it is not the only thing, and it is not sufficient. The legal processes are not sufficient. So we moved on to investigate about the determinants of corporate bankruptcy, and when you type the word of corporate bankruptcy in the Scopus database, around 1500 articles appear, and we looked into, we did a bibliometric analysis of those as well, and we found based on the citation scores, normalized citation scores, we found which are those influential sources, the author affiliated countries, and the articles which talk about corporate bankruptcy. Also, there is this financial stability report of 2021, which tells that the longer time the bad loans spend on the balance sheet of a company is inversely related to the proportion that is recovered by the banks. Also, there is a study by Devi Prasad Rath and Sujesh Kumar. It is an RBI paper. It tells about the leverage investment nonlinear relationship. So it basically investigates what is the investment dynamics that is evolving in India, and it gains new insights into this. So it finds that financial variables play a critical role for the investment dynamics, in addition to 2 variables. One is the business expectations, and another is the EPU, which is the economic policy uncertainty. Now coming to the economic policy uncertainty, this is an index which was designed by Baker et al. In 2016, and they came up with an index. So on the basis of that India's score was 76, around 76 in 2016, and at present, as of March 2022, it is 125. So generally one would think that the economic scenario is more certain now with respect to what it was in 2016. But if you see the gross NPA to gross advances data from RBI, the NPAs have increased a lot. So this ratio has increased from 2.3 to 7.3 in the last decade. So this was basically what motivated us to study what are the causal factors. We were curious to know the factors behind the corporate bankruptcy trend. So we formulated our research objectives accordingly. So we had gone through various literature, and we found literature which classifies uh, bankruptcy regimes around the world on the basis of pro-liquidation and pro-reorganization regimes. There were also studies which focus on strength of the banks, strength of the economy, and explain it through a game theoretic models. Also, there were studies on creditor rights. For example, the La Porta 1997-1998, which was extended by Jankov 2007-2008. So they explain what is the role of creditor rights in the debt market development, and as well as the defining the bankruptcy in a country. And so they had come up with an index as well. So we also looked into that. And as I said about the bibliometric analysis, so these are the top 5 sources of information on corporate bankruptcy. And, and those are the 5 author-affiliated countries which are producing publications on corporate bankruptcy. So regarding data collection, our sampling technique was purposive sampling, in which we took data from IBBI website. We collected a sample of initially 2,265 firms, which were categorized into 4 components. The first one was CIRP, which was yielding into resolution plans. The second was CIRP ending with liquidation, and the other 2 were liquidation and voluntary liquidation, which ended with dissolution. So apart from the firms which were recovered, we we defined bankruptcy on the basis of these 3, and our total sample size was 1,844 firms, and the study period was 2017 to 2021, and these are the various data sources which are credible sources of information. So regarding the variables which were used, so we have the dependent variable construct as the bankruptcy trend, which was defined by the indicator variables of the 3 which I mentioned. Then there were the independent variable constructs, which were captured by various variables on which data were available. And also from the debt market dynamic point of view, we tried to capture the public debt as well as the private debt. So the public debt, public issues of corporate debt, as well as the corporate bonds and NCDs data was also captured from the SBI database. Next, about the methodology, my colleague Shashank will explain.
Thank you, Abhishek. So when we have identified our variables, we ran forward to explore what are the factors that are contributing to the model. And running exploratory factor analysis using PCA, that is principal component analysis method, we came that 4 variables were contributing mainly to the model. As you can see on the diagram, the scree plot, and also confirmed by the total variance explained. The 4 components were held more contributing to the model, and the first component was solely explaining 49% of the variance in the model, and in taking all the 4 components collectively, more than 85% of the variance was explained. In the latter part, looking at the rotated component matrix table, in the first component, gross advances, CPI, GST collection, external sector debt, forex reserve, private placement of corporate bond, and outstanding corporate bonds were the variables that were included in the first component. In the second component, GDP growth, GST collection, net FDI. In the third component, credit to deposit ratio, trading amount of corporate bonds. And in the fourth component, GST collection and public issue of corporate debt was included. As you can see, it was very difficult to club these variables into one component and provide a particular justifying nomenclature to the component. We went a step ahead to perform the PLS SEM. We went perform PLS SEM to know what are the really contributing factor to the model. because in the PCA we were not able to club our variables into one construct. We use PLS-SEM. The question arises why we use PLS-SEM. So as per here 2015 and 2019, PLS-SEM is a good technique when we have secondary data or when we have financial ratios in the model. So we went to perform PLS-SEM, and why we are calling is recursive. It is having because our path analysis is showing a one-directional or unidirectional causality. So the unidirectional causality of path analysis is termed as recursive, as reported by Latan and Ramli 2014. Therefore, we are calling it a recursive PLS-based model. So we ran the PLS-based model in three different hierarchy. Our initial model was having all the 20 independent variables measured in three different constructs, and one dependent variable measured by three different variables. First order model showed that the debt market dynamics is not contributing significantly to the model, therefore we have to remove it. In the second order model, again we found that there is still some covariances which are less than 0.5, so again we have to remove it. And finally in the third model, the model was, as you can see on the screen, this model came as our final model. So condition of banking sector was solely explained by credit to deposit ratio. Economic condition was explained by GST collection and external sector debt, and bankruptcy trend was explained by total admitted claims during CIRP, ending with the order of resolution. Now coming to the model fit indices of this model, we had adjusted R square of more than 52% and R square of more than 60%. SRMR value was less than 0.8, citing Hugh and Butler 1999 and Bentler and Bonnet 1980. So when it is less than 0.08, it is a good fit, and NFI, that is norm fit indices, it should be again, it is like a correlation matrix. So as close it is 1, the better it is. Coming to the construct reliability and validity, which is measured by Cronbach alpha, composite reliability, and AVE. Cronbach alpha should be 0.7 or above, which is confirming in our model. Composite reliability should be again 0.7 and above, confirming in our model, and AVE should be 0.5 and above, confirming in our model. Coming to the discriminant validity, which is a measure of external consistency, it can be measured by two criteria. One is Fauner and Larker criterion, and other is STMT. But STMT we have reported here. We have reported Fauner and Larker in our paper, but STMT ratio is considered above and better than Fauner and Larker, as reported by Hensler and Sarstedt in 2015. So STMT ratio should be less than 0.8, and our model is confirming that also. So we have also reported AVE for issue of multicollinearity in our paper, but due to some constraint, we have not included it in our PPT. So the result will be again explained by Abhishek. Thank you.
So as we see from the slide that our study proves that the bankruptcy trend is significantly caused by three factors, which are the credit deposit ratio, the external debt, and the GST collection. So a higher credit deposit ratio means that the balance sheet is overstretched, and therefore there are certain capital adequacy issues in the bank. And also with regard to the external debt, our results support a previous study which was done by Schwartz and Martin, which also came up with the same result, that a higher level of external debt contributes to a higher bankruptcy risk. With respect to the tax avoidance, our study actually extends a study of Richardson of 2017, which tells that a higher level of financial distress is caused by the tax avoidance history. And our study proves that tax avoidance history also contributes to a higher bankruptcy that is defined. So coming to the implications, we explored the macroeconomic factors in terms of an uncertain economic environment. And as we know from the various discussions in this conference, that generally in the past 5 years of IBC implementation, value destruction has happened in a pro-liquidation firm because of the capital in control However, there is a study of Aditya Kaushik of Niti Aayog which proves, uh, which says that in terms of the value of the assets, the rescued firms is the value is 4 times more than the value of the liquidated firms. Also, this has implications in terms of reducing the congestion in the bankruptcy courts, the NCLTs, and also it provides insights for regulations in future. Coming to the limitations of our study, so a more granular data would have revealed more insights into this. Also, the data unavailability with respect to certain variables made us exclude those variables from the study. Also, in terms of the future scope of the study, it can be studied with respect to exogenous shocks. For example, the pandemic which occurred, it was a once in a century phenomenon. So those are certain exogenous shocks which can be considered, and also with respect to the recent initiatives that are being taken by the present government in terms of the bad bank, also the same committee report on ARCs which has been submitted. So these are future areas to study. Coming to the conclusion, our study has found a unidirectional causal relationship between the bankruptcy trend and the 3 variables. So our study is unique in 3 ways. So first is this unidirectional causal relationship which has been established for bankruptcy trend, and also with respect to the temporal significance. So we stand at a 5-year period of implementation. So future researchers could look at how other insolvency regimes in the world, what was their position after 5 years of implementation. So this can be looked after by future researchers. Also, in terms of the regulation, our study could help to improve the regulatory reforms in the bankruptcy regimes in India in future. Thank you.
Any questions from the house?
So,
Not 468, the sample was 1844 firms which have been liquidated. So it is directly from the IBBI website.
so sir, this is a bibliometric analysis? Or
Sorry?
this is
No. The literature review part was a bibliometric analysis, yeah.
And what software did you use?
VOS, viewer, yeah.
It's for me, it's not exactly a question, but kind of clarification. 2016 onwards, that's your data period. You would see that Indian private banks had much higher credit deposit ratio than Indian public sector banks. So on an average, Indian public sector banks had around 56 to 60% credit deposit ratio, whereas Indian private banks had 75 to 80%. But your results suggest almost opposite. Private banks actually, bankruptcy trend is much lower than the public sector banks.
Yeah. So I would like to answer that. So you are talking about a period 2016. Okay. Okay. So because I came across a data of RBI regarding non-food credit. So in that, so while I was studying this, so the period before the financial crisis of 2008, that was a private corporate debt-driven growth story. There's a paper on it. And also, so the period after that has shown a subdued credit growth. So I was seeing at the data. So the RBI data of non-food credit suggests that the trend has been up and down. So so actually it went up, it dropped just after the crisis, and then again it went up around 2015 and 16, and from then it has been dropping till 2020. And further after 20 I didn't see, because after 20 there was an pandemic situation, so obviously abnormality will be there. So yeah, so that I wanted to say.
Okay, so I have few observations, the first thing is that what I feel is you have focused too much on the, techniques, statistical techniques, like you have used bibliometric analysis, EFA, PLSM. I think more time should have been given to model definition or preparing the conceptual model for this. Uh, you are using EFA, but I do not see any need for using EFA because you already have fixed variables which you have identified. EFA is used to identify the variables, but you have already identified it, and you only have to confirm whether your model confirms to these variables or not. And coming to your implications, like you said, it has some insights for regulators. So what are those insights? Can you elaborate on that, please?
Yeah. So, in terms of following yesterday's discussion which we had during the inaugural address, so there are certain areas which they are looking at the IBBI. So one is that in fact, the chairperson himself said that it takes a lot of time for a case to come to under IBC. So that was one of the points which was mentioned. So invariably, the time to resolve, the time period with respect to the law will not be followed if it enters late, like it is admitted late. So because it gets admitted late, so that's why this study can help in improving that time period. So suppose there is an NPA situation in a bank, and further it worsens, and then the company goes into, is admitted into the CIRP process. So our study could help in controlling it just at the NPA stage. So that the financial distress situation is not worsened enough so that the companies go into the CIRP process. So there is Banking Regulations Act, and there is a bankruptcy reform, that is the IBC, which is there. So the congruence between the two should be there. So suppose we have the PCA framework or prompt corrective action, so how that would help to control the number of companies going into CIR. Yeah.
Okay. Abhishek, I think on those slides you said tax avoidance
Yes,
is a marker for distress or about to become distress.
So tax avoidance history, yeah. So the companies having higher level of financial distress the previous studies have shown that they have a tax avoidance history.
So did you do that study in the IBC itself?
No. My study was different, ownership
was,
structure.
Okay,
Yeah.
that was a literature review you were referring to.
Yeah. So it is Richardson 2017.
And was it surprising that it could be leading to distress?
It was surprising because we didn't think initially about the tax aspect of it.
But I thought it was understandable.
Yeah.
No, that's fine. Thank you.
Any more questions?
Just one short question. Some of these variables, of course, you mentioned that you established causality, but being an outsider, for example, even tax avoidance, what causes what? I'm kind of puzzled, right? Does distress cause one to avoid tax, or tax avoidance leads to distress? Of course, I think you addressed it methodologically, I think.
Continued tax avoidance could lead to financial distress.
Because theoretically, I can justify the other way around, right? I mean, I can see that, someone going through distress will go and avoid tax, right?
Yeah, I said higher level of financial distress. Okay. So,
Hi, I have just one small question. In your research implications, you have written value destruction in pro-liquidation regime. How have you arrived at that implication? So
my previous study is on value creation. It has been published. So it is on value creation with respect to M&A. So there is evidence in which companies go for acquisitions to reduce the bankruptcy risk. Also, there are literature on companies diversify their firms to reduce the bankruptcy risk. So when a company goes into liquidation, definitely the company is dissolved and its assets are sold. So, so the value of the company in terms of the valuation, I feel like in the liquidation, the value is getting dissoluted, right? So in case the company is resolved, like the rescued, so that time the company is a going concern. So, so I also mentioned during the PPT in terms of the value of the asset, there is a Niti Aayog study which tells that the rescued firms contribute to 4 times the value of the liquidation.
Sir, ma'am, actually I have one point. Sir, as you said that in 2008 and 9, like as the economic crisis took place at that time, so NPA's trend was not there. Actually, that was in growth, but after that, that was lead to growth. And in 2015-16, as you mentioned, that it was like slow down. But I saw on the reports and this trend and progress of RBI, so that was increasing at that time. So
No,
I
I
just
said,
little doubt about that, whether what exactly.
yeah, I said post the crisis, just few years, for few years, there was subdued credit growth.
Thank you.
The second paper for today deals with the conundrum of claims in corporate insolvency resolution process. The presenters are Anshul Agarwal, Akash Chandra, and Raghavi R.
Good afternoon to everybody present here. The paper is written on the conundrum of claims under the CIRP. We believe that the concept of claims under the code warrants a deeper understanding so that an effective CIRP may be ensured. Claims are central to all insolvency jurisdictions. They give participatory right to creditors in insolvency, and ensuring a due process for claims for such stakeholders is very essential. The understanding of claims is also very important because on the successful approval of a resolution plan under the code, the impact on claims is such that they stand extinguished. Therefore, it becomes imperative to know what a claim encompasses and how they need to be treated under the code. Additionally, the understanding of claims also becomes relevant for the IRP under section 21 of the code, where he would be determining the financial position of the corporate debtor. There has been divergent and varied views by various courts with respect to the conundrum of claims. We, as authors, we seek to find a solution in this conundrum that would correspond to the scheme of the code. So that's what we seek to present today. Therefore, in this background, we seek to present a legal perspective on what claims are and how they may be treated under the code. Various tests have been used in varied jurisdictions to determine the trigger point of insolvency. Some of these include balance sheet test, cash flow test, among others. In India also, earlier we had the test or the concept of inability to pay debts. However, currently, the legislative intent has shifted to the default test, which is more of an objective test. Default under the code has been defined as the non-payment of debt, which has become due and payable. Debt is also defined under the code to mean a liability or an obligation in respect of a claim, which is due. A creditor is any person to whom a debt is owed. Existence of default and debt leads to a trigger of CIRP under the code. There might be a number of defaults that the corporate debtor would have committed during his business, but it so happens that one of them leads to the triggering of CIRP under the code. On the other hand, claims are of a wider connotation and they are wider in ambit. Claims become relevant once a CIRP is triggered. All claimants need not be creditors under the code. Claims are denoted by a right to payment, and it does not necessarily require any other factor such as an obligation or a debt being due or payable or otherwise. The only requirement is that there should be a right to payment. Therefore, a CIRP stands on the fundamental concepts of debt, default, and claims. We have attempted to draw an inference on how debt, default, and claims are interconnected. So what we have come across during the scope of our research is that in practice, the legal difference between a claim and a debt is becoming diluted, and claims are mostly understood in the context of liability or an obligation which is due. However, it may be seen that all debts are claimed in the first place, but not all claims would qualify as a debt within the definition of debt provided under the code. Therefore, the concept of debt, default and claims are definitely interconnected in nature, with claims among them being the widest in amplitude, and it becomes imperative that this widest amplitude claims should be explored further. IBC has been inspired from the English law. The role of the RP can be roughly equated to that of an administrator in the UK. The IBC was drafted by BLRC, and they refer to various jurisdictions for making the best suitable legislation in the Indian context. We found that the definitions of debt and claim under the IBC are similar to the ones used in the US bankruptcy code. In earlier statutes, only certain or absolute debts were provable in bankruptcy, but over time what we saw happened was the class of provable debts itself have enlarged in scope, and it lead to the two concepts, provable debts and non-provable debts. In the Indian context, the understanding of claims was present in the company law regime and the personal insolvency laws, wherein the claims are to be supported with proof. A broad category of debts as well of liabilities encompassed debts provable in insolvency, and the manner in which they may be proved was known as proof of debt. Although the concept of debts provable or non-provable in insolvency was not extended under the code, the inclusion of a wide definition of claim suggests that the legislative intent was to allow the submission and treatment of all kinds of liabilities and obligations that arise against the CD during the CARP. This idea was also highlighted in the BLRC report in 2015. Now we move on to interpreting the definition of claims under the code. The definition of claims is provided under section 3(6) of the code, and it covers two broad rights. A being the right to payment, B being right to remedy for breach of contract where such a breach gives rise to a right to payment. We understand that the claim only requires a right to payment to exist, and the use of the phrase whether or not in the definition implies that the right to payment may or may not be fixed or subject to a judgment, matured, unmatured, secured, unsecured, or otherwise. This further implies that it also covers debts such as contingent debts, future debts, and other claims from where a right to payment can emerge. The definition of claims also recognizes that claims can be determinable and indeterminable in nature. In the event of an indeterminable claim, the code also provides for the best estimate to be done of such claims. This definition of claim ensures that all the creditors are given due consideration during the CARP, and it helps the RP to ascertain the financial position of the CD. It is for the benefit of the resolution applicant that this is to be ensured, and it also lastly establishes the voting rights of the financial creditors. RP would be taking over the management and the control of the CD, and he is to be well informed about anyone and everyone who has a right to payment against the CD. Not all claimants may be creditors. However, that does not mean that such claimants need not submit their claims to RP and participate in the CARP. This is essential because the effect of the code is such that all claims and not just debts are extinguished on an approval of a resolution plan. Therefore, we believe that this scope of claims under the code should be focused upon, and it should be advocated better for the benefit of all the stakeholders. Now that an understanding of what claims are have been addressed, we seek to highlight the process as to how such claims may be considered and treated during a CARP. The IRP or the RP is required to receive and collate the claims under the code. The regulations also supplement this role of the IRP and RP by providing that they must verify each and every claim and determine such claims whose value may not be determinable due to them being contingent or unliquidated or otherwise. Such claims are valued. They are to be valued based on the basis of best estimate practice. Here the role of the RP as a professional becomes very essential. In exercise of his professional wisdom, he has to examine the claims, compare it with the documents available on record, and determine the financial position of the corporate debtor. He acts as a facilitator of the corporate insolvency resolution process, and his role is definitely administrative in nature. This role has been clearly recognized under the code and the regulations, and it has also been upheld by the judiciary. This role becomes even more important as the approval of a resolution plan by the COC in exercise of their commercial wisdom extinguishes all claims. Therefore, the administrative role envisaged, it does not entail that the role of the RP is devoid of any application of mind at all. Rather, he is expected to act with utmost diligence and due care while dealing with claims. He is not expected to exercise adjudicatory function in respect of a claim. He is not to sit as a judge and determine the rights and liabilities of each claimant. It is for this reason that no appeal has been provided against such action of the RP under the code, because in the first place there is no adjudicatory decision based on which there could be an appeal. Therefore, the office of the liquidator is differentiated from the office of an RP in this regard. We have observed in our research that there are many applications that are filed as challenges to the decision of the RP on a claim. The AAs are also adjudicating on such claims, and they are determining the rights and liabilities in respect of such claims. We believe that Section 60 Clause 5 provides fresh jurisdiction to the adjudicating authority to deal with claims, and the first consideration before the AA should be to see if the RP has acted with prudence and reasonable diligence while dealing with claims during a CARP. If the same is shown before the AA, AAs may refrain from determining the claims afresh. If a fresh consideration of all claims are permitted under the code, under Section 60 Clause 5, it would defeat the very objective of time-bound resolution under the code. On that note, we seek to throw light on how the treatment of claims during CARP in India may be differentiated from the processes under the UK and US jurisdictions, and there are certain learnings that we can take from such jurisdictions in the context of valuation of claims. As said earlier, the definition of claims under IBC is similar to that under the US bankruptcy law. However, the approach in treating claims have always been judicial and equitable in the US, as it is the courts in the US that facilitate the whole process and adjudicate the claims. Similar is in the case with UK, where the administrator is to give reasons for admission and rejection of claims which are applicable to the court. In the UK, the role of an administrator and liquidator are equated with respect to claims. However, the role of RP and liquidator is very different in India. This approach is not suited to India, as under IBC the role of IRP and RP is clearly drawn, and the CARP is a time-bound process with minimal court intervention. This is why, though the broader framework of the insolvency law in India is comparable to that of the UK and the claims under US, the process of treatment and the adjudication of such claims is very different in India under IBC. For consideration of claims during liquidation, a corollary might be drawn to US or UK, but the same may not be suitable for a CARP. That being said, we found that there are certain rules and practices present in the UK and US regarding the treatment and valuation of certain types of claims. For example, we have trade discounts in UK, where all trade and other discounts would have that would have been available to the debtor, but for the insolvency proceedings must be deducted from the claim. And there is also a practice in UK where contingent claims are valued based on genuine and fair assessment test, based on the chances of the liability occurring. The court sees if any other reasonable prudent liquidator would have come to the same conclusion. And there are certain other rules relating to the treatment of periodical claims, interest amounts, mutual set-off, and counterclaims. We believe that adoption of similar rules in India could enable the IRP and RP to effectively determine and value the claims, and it would also determine AS to check the action of the IRP and RP in treatment of such claims. Similar rules were also found in the Provincial Insolvency Act, which is not present under IBC. These rules and practice would guide the RP and facilitate him to deal with claims in a systematic and a uniform manner, and it would enable him to complete the claims with keeping in mind the time-bound obligation under CRP. With this, we conclude that the advocacy of the legal concept of claims is necessary for enabling all the stakeholders to file their claims, considering the aspect of extinguishment of claims. The administrative role of the RP and IRP during the CRP with respect to claims need to be understood, and the AA would sit to review such administrative action taken by the RP and IRP. This will ensure limited intervention of the AA in determination of claims during CRP stage. Finally, for indeterminable claims, we propose that, such as contingent claims, rules available in jurisdictions such as US and UK may be referred for adoption in context of India, which would act as a starting point for effective claim management. We conclude by saying that such reforms may be useful as CRP accelerates timelines of claims and they get extinguished on approval of resolution plan. Thank you.
Anshul, can you sum up in 2-3 lines your problem statement and what you are proposing?
So there
Because most of the time some provisions under the code was explained, and that resolution, once it is finalized by the authority adjudicating, so there is a freeze for the pending claims. So that is final, even act has been amended. So I don't see any problem, which is
so
only thing advocacy is required for this purpose. People should file claims quickly, something like that.
Correct.
Is it your problem statement?
So there are three aspects that we have tried to cover in this paper. One is that of the understanding of the claims. So we are saying that what is happening is that the understanding of claims is getting confused with the understanding of the debt. The claim is much wider in nature, and because of the claims, the RP under section 21 is actually bound to determine the financial position of the CD and then constitute committee of creditors. So therefore, this understanding of claims is very important, and every right to payment, whether or not such right has been reduced to judgment, matured, unmatured, should be given, should be coming up before the RP when he calls for the claim. That is one aspect.
Is there any restriction for that?
Sorry.
Is there any restriction that claim cannot come?
There are.
An item is issued, invited, or
There are no restrictions as such. How?
What is the problem?
Yeah. No, the problem what we have faced, like through reading of the NCLT judgments and also the practice which has been happening. So we have found that only people who are having a debt claim against the CDs are filing their claims. But therefore, there is a limitation on the RP's part to determine a kind of a financial position of the CD. So therefore, we want to advocate this point that the understanding of the claim should be explored. Second aspect of the paper is that the role of the RP in determination of the claim, that has to be understood, and that has to be distinguished from the role of a liquidator in a liquidation proceeding. What is happening is that what we have seen, and also there are many different opinions coming from the NCLTs, and also the practices which are followed by the RP, that they are ending up being determining the rights and liabilities of the claimants. But that is not the purpose. The RP is supposed to collate the claims. He has to use his best diligence on the basis of the proof which has been given to him. And then only he will determine a particular value to that claim. That does not mean that he has to pass a reasoned order after hearing both the parties, and then that kind of an approach of that of a liquidator. So therefore we say that the office of RP is different from office of a liquidator, and that difference has to be appreciated. So these are the broad 2 points. And the third point, which is what practices from UK and US we can take on the assessment of a claim. We have seen that in US and UK, the broad approach on understanding of the claim is actually based by the equitable jurisdiction and also by the interpretation by the courts. So therefore, on our first two understanding, we cannot adopt that kind of an approach. However, we are saying that on the best estimation case, which is also provided under the code and the CRP regulations, some principles or some rules on how the best estimation can be done can be adopted from that context, from US and UK context. And that is what she has highlighted, that these are the principles that we can adopt in Indian context so as to help the RPs to make a better determination of the claim.
Anshul, while you have spoken about the conundrum in respect of the verification of claim, I am talking from the point of view of the IP or the RP, those who have to do all this complete exercise, which is a very complex exercise, as well as the lengthy one also. Imagine the time given is 7 days after the submission of the claim.
Exactly.
And the claims vary from, say, hundreds to thousands of the claims are there. One is this period of 7 days. Don't you feel that there is a requirement of some flexibility in this period? Second is, what about taking, because the whole responsibility is of the RP, even though he may be taking some support from the other staff and all in verification of the claim, which most of the RPs do that, but the ultimate responsibility remains with the RP himself, and he cannot pass it on to the others. And there have been in the past many cases where the RPs have been admonished on these things. So have you assessed or examined from this point of view that this period of 7 days for the verification of the claim, there should be some flexibility depending upon the magnitude of the case, magnitude of the claims? Thank you.
So I see there are two aspects of your question. So dealing with the first aspect, we have seen that, you know, the CIRP regulations, they provide that in case the claims are not filed for in the T+7 days, then an extension of 90-day period is there. And therefore the determination. Exactly. So exactly, we have not covered as to whether that 7-day period should be extended or not. But we have tried to understand what should be the role of the RP under the when he deals with the claims. So then we have said that what is the duty expected of the RP? The duty which is expected of the RP is to see what is the proof given. He is not to adjudicate, and that is how he has to look at the other documents which are available from the city and come up with a value. Apart from that, there's nothing more expected of the RP in a CRP process. Therefore, we believe that scenario can be covered in that aspect.
One question, please.
So on a particular date, on a 30th day, when I have to file a claim, whatever claims received, that becomes a COC. It doesn't stop claimant not to file the claim later on. If a verification 30 days are over and somebody files a claim after, say, 2 months, then the claim also again has to be verified and admitted.
I think we are slightly discussing a different aspect here. Of course, 7 days can be restricting if an IP has to, go through a lot of documents for proof and everything. But in most cases, we have seen IPs try and get it done by the 7th day so that they can inform the claimant about the credit. But that 7 days in particular, of course, where it's difficult, then everybody else also understands it's very difficult to come up with a result in 7 days. So I think market has developed its practice in kind of meeting that timeline, and where it's necessary, it is extended, and I think the claimants also understand. And while RPs update the claim forms in the IBBI website, we see that RPs generally do it on a fortnightly basis. So it seems to be working fine, though there are some difficulties for RPs.
One question, please. Please.
Governance point, which for all RPs, which we actually do it, we take up the balance sheet and we go out of the way to write to the creditors who are shown in the balance sheet. We don't wait, because there are a lot of operational creditors, a lot of MSMEs who probably might miss out the advertisement. So we make it a point that we write to the creditor as a part of a corporate governance. Whoever is appearing as a creditor in the balance sheet, last balance sheet, whatever is available to us, we will write to them, we will send them this claim form to fill up and submit the claims. I think that should be done by almost every IP.
Thank you.
Yes.
Sir, one of the gray area which still surmounts is about the disputed tax liabilities and other contingent claims. So based on your research from US and UK model, do you have any better alternative, because Supreme Court judgment suggests giving a notional value of 1 rupee to those contingent claims. So do you have in your research any better idea, proposition towards those contingent claims?
So with respect to contingent claims, we have found that in the UK legislation, they have come up with this best and fair assessment, in which the test which has been laid down is that if a similarly placed resolution professional would have come at a similar kind of a calculation of contingent liability. And that is the only test which is to be done, made by the judiciary while determining while adjudicating on a contingent claim. And the RP also, and the base of facts and circumstances, has to come up with a particular value on that contingent claim. As such, there are no strict principles on how a contingent claim. Thank you.
The final presentation for today's session revolves around the topic, the need to improve insolvency governance for committee of creditors and resolution professionals to safeguard the goal of corporate rescue. It would be presented by Professor Priya Garg, Ms. Trusha Modi, and Ms. Bala Pragata M.
Thank you. First of all, despite it being an honor to speak here, it is quite overwhelming to speak physically before an actual audience, I think after about 3 to 4 years. So first of all, I would like to thank IIM Ahmedabad and IBBI to organize a conference in a physical format after COVID. Now it's also a very proud moment for me because today the paper that we are presenting is something that the idea for which came to me during my master's, and actually my students, Bala, Pragita and Trusha, sort of took a lead on developing the paper and refining the arguments. And this is the reason in our presentation, while I'll be presenting the introduction to the idea which came to me and the conclusion, Bala, Pragita and Trusha would be respectively discussing the detailed part of the paper. So the topic of our paper is the need to improve governance standards for committee of creditors and resolution professionals to safeguard the goal of corporate rescue. Now, actually, this term, which is insolvency governance, is something that is very intriguing because there was a time in company law around 1990s when all we cared about was profits of the company. We really didn't care about how those profits were arrived at. So we really didn't care about how the decisions were taken in the board meetings and in the shareholders meeting. But then in India, as well as abroad, we got a lot of scams, right? So in India, we got Satyam scandal, for instance. And because of all of that, there were a lot of corporate governance reforms that were introduced to the field of company law. And even today, the Companies Act 2013 that we have is very high on governance standards. Now, I sort of drew idea from there and transported it to the field of insolvency law, which is currently, in terms of its scholarship and jurisprudence, very much confined to the principles of economics, property, and so on and so forth, but not so much on the principle of governance, which means the focus on the fact that once insolvency process has begun, be it the resolution process or the liquidation process, how exactly the decisions are taken, who are the actors who are participating, what is their eligibility criteria, how the decisions are actually arrived at, basically focusing on the how aspect and not just the end goal aspect is the whole idea behind the conceptualization of discussion on insolvency governance. Now today in this paper, while there could be various ways of improving insolvency governance, we'll be focusing on two institutions. One is COC, which is Committee of Creditors, and one is RP, which is Resolution Professional. One of my students will be presenting on how the institution of COC can be made to function in a more transparent manner, and likewise the other of my student is going to present that how RP's institution and eligibility criteria can be made more streamlined so that there is more element of accountability, basically focusing on the how aspect of the result as well and not just the end result of maximizing the pie. Thank you so much.
Good evening, everybody. I will be right now talking about the issues with the constitution and conduct of COC. Like Professor has mentioned, there are multiple issues with the functions of COC, and it has been identified by the Standing Committee and IBBI discussion paper. But right now, for the purpose of the presentation, we are focusing on 3 specific issues with respect to the constitution and conduct of the COC, which directly affects the goal of corporate rescue. So we are amplifying on the goal of corporate rescue, and we'll be discussing how these 3 main issues of the COC affects that particular goal. So firstly, under the constitution of COC, I'll be discussing I'll be discussing the issues with participation of the related party in the COC process. As we know, related parties cannot be part of the COC decision making process, and this is particularly provided in section 21 and section 43 of the code. However, there are multiple circumstances where due to certain lacuna in the law, related party tend to participate in the COC's decision-making process. And as a result, it could potentially result in avoidance transactions, and which subsequently could erode the value of the company, and this directly relates to the goal of corporate rescue. So in the paper, we have discussed how these avoidance transactions could result in ridiculing the goal of corporate rescue. And specifically, we have discussed multiple cases which deal with the issue of related party transaction. Specifically in Fortune Pharma Private Limited, one of the corporate debtors, they signed the corporate debtors was the director of the company, and the director of the company, through an assignment agreement, assigned the debt to a third party. Now that non-related party was part of the COC decision-making process, and SBI was one of the other corporate debtors. Now, because of this assignment, the voting share of SBI reduced drastically. And because of this, they were able to control the decision-making process indirectly as well. So this was considered to be a sham transaction, and something that NCLT also has noted that shouldn't be allowed. However, as the provision, the code does not specifically state that past debtors, any relation with the past debtors should also be, should be brought under the purview of related party transaction. There are scope to involve such related party in the decision-making process, and this has been discussed in the Supreme Court's case of Phoenix Arc as well, where the court has said that any sort of sham transaction should be avoided. However, we are of the opinion that given that it's not specifically mentioned in the code whether a past debtor can be part of the resolution, the COC's decision-making process or not, and there is a lack of explanation about that, there is still certain confusion that revolves around this particular issue. Secondly, with respect to conduct of the COC, we are now going to discuss two main issues. We have discussed other issues in our paper. However, we'll be focusing on two main issues. One, the participation of inadequately authorized representatives in the COC process. So in multiple circumstances, what happens is the CD nominates a representative. However, this representative does not, they don't have the sufficient authority to make any final decision. So they are merely listeners and note makers, and later they have to relay this information to their senior authorities, and then a final decision will be taken. This clearly results in delay in the decision-making process, and throughout the conference we have heard how delay is the main issue that's facing, that has to be changed in the IBC regime right now. So regarding this, IBBI had actually issued a circular stating that only authorized personnel should be taking part in the COC decision-making process. However, what happened in the IBBI circular is it puts the onus on the RP to ensure that only authorized person can take part in the decision making. However, we believe that it's more important to place that onus on the COC to state that only they can only send an authorized representative to the COC meetings. Thirdly, secondly, under the conduct of COC, this issue has been widely discussed and has been addressed at multiple times during the conference as well. The issue with wide discretion of COC. I don't want to get into what are the consequences of this wide discretion and the multiple instances where it has been misused. We have listed few cases which discuss this and which amplify on the issue about this. However, we want to focus on the code of conduct which has been circulated by IBBI in response to this wide discretion given, and the idea behind the code of conduct was to regulate the unregulated environment of COC's decision-making process. So we believe that it's a very welcome move. However, we have certain critique about the code of conduct. Firstly, we believe that there are certain terms in the code of conduct which are very uncertain and ambiguous. For instance, the code of conduct states that the COC has to maintain integrity and maintain objectivity while making decisions. However, what is the standard for evaluating integrity or objectivity is not provided. Now, if we were to introduce this code of conduct in the present form and attach it to the IBC code or any other parallel regulation, what could happen is Now, this code of conduct could be considered as a law. And if we were to consider it as a law, then the court again can come in and interpret what each of these terms mean, which will again result in more judicial scrutiny, which has been widely accepted that it should not be the commercial wisdom of COC should not be scrutinized. Therefore, we believe in our recommendation, especially with regards to the code of conduct, that instead of making it a specific law or attach it to the code of conduct, the existing regulations, for instance, the regulation by SEBI or RBI, should be extended to the creditors as well. And this also promotes the inter-regulatory aspect that MCA wants to promote. Therefore, just extending this regulation could be a better approach rather than introducing the code of conduct as a law. And we have also listed few other recommendations. Firstly, with regards to related party transaction, we believe that written compliance should be taken from the COC, that only authorized person will be sent to the COC decision-making process. And secondly, with regards to the haircuts given, we believe that a higher upper limit of haircuts that could be potentially given could also be included in the regulation, so that the COC have some standard while issuing haircuts in the process. So this is the overview of what we have discussed in our paper with regards to issues with COC. Now I would like to invite Tushar to talk about the RP, issues with RP.
So the governance issues with the institution of RP would be elaborated in three parts. Firstly, there is a lack of independent standard between the resolution professional and the committee of creditors. Secondly, there exists also a lack of independence between the RP and the resolution applicant. And thirdly, there is an overemphasis on the independence between the RP and the corporate debtor. So for the first part, as we all know, as soon as the CRP process starts, the resolution professional is handed over the management and the day-to-day operations of the company. So his role becomes important for the efficient operation of the CIRP process. However, the powers given to the RP is limited and subject to the authority of the committee of creditors, due to which the committee of creditors have an external influence on the decisions of the RP. And because of such external influence, the independence between the two is important to have a bias-free process, and impartiality of RP becomes really important, so that this process does not only benefit the creditor but also all the stakeholders involved. So the lack of independence that hinders the goal of the IBC, that is value maximization of the assets of the corporate debtors, was highlighted in the Binani Cements case. So in this case, because of the partiality of RP, there was a better resolution plan was discarded, which as opposed to a plan which only benefited the creditors. So there is a code of conduct for the insolvency professional, but it is silent and does not have any specific provision where the RP and COC should not be a related party or they should be completely independent. The code does specify the requirement of disclosure of any personal or pecuniary relationship, but there exist two problems with it. First, the code is silent on the breach of it, and secondly, if there is a majority creditor, he can appoint a non-independent RP as well. And the second issue is between lack of independence between the resolution applicant and the resolution professional. Such has been highlighted by previous researchers as well, and was noted in the Ruchi Soya Industries Limited case, where there was a conflict of interest because same law firm represented the RP and one of the resolution applicant, that is Adani Wilmar. So therefore, the lack of lack of standards, ethics and proper framework for the functioning of the resolution professional will hinder the goal of corporate rescue, as it will discourage resolution applicants, especially foreign bidders, to submit a resolution plan. And as noted in the panel discussion today, there is a need to have multiple bidders and for value maximization of the assets of the corporate debtor, so as to have a CIRP process that benefits all the stakeholders that are involved and not only the creditors. The third problem is that of the information asymmetry. So even this problem was highlighted to an extent in the panel discussion today, where the promoters are ineligible to submit a resolution plan. However, the corporate ownership pattern in India is concentrated, and they possess the vital information which can prospectively lead to the corporate rescue of the distressed company, though there is no denial that the promoters or the existing management might be responsible for the company's distressed position. However, insolvency is a economic failure and not a moral failure. Therefore, the code using one-size-fits-all approach regarding the treatment of promoters and management can can cause an hindrance in achieving the goal of corporate rescue. So, the suggestions with respect to this is that India can adopt provision similar to UK, where there's a insolvency practitioner code of ethics for which has objectivity as one of its principles, mandating the RP to not allow bias, conflict of interest, or undue influence to override his professional or business judgments. Further, the conflict of interest could be countered by information barriers such as secure filings or confidentiality and terminating relationship. Further, a penal provision similar to section 184 of the code could be implemented. So thank you. The professor would conclude the paper.
Thank you. So with this, we talked about how the institution of RP and COC can be made more accountable, more transparent, and not just focus on arriving at the end goal, but also the process through which we go there and arrive at the end goal. And with this, we would leave with a question, which is that to what extent we can be inspired by company law when we talk about discussing the governance standards for RP or COC. Because the issue is that what is the role of directors when the company is alive or is an ongoing concern is sort of split between COC and RP when the company has entered into troubled waters. So to what extent we take clue from the way we have designed the institution of directors, etc., to apply to the governance standards for COC and RP is something that leaves us thinking, at least leaves me thinking. So with this, we would like to conclude. Thank you so much for your time.
So I will just start with one question. Vidhi, you are proposing this under the code of conduct, this provisions of SEBI and RBI. I think disciplinary provisions you are. What provisions you are saying that this should be made part of the insolvency system or the?
We are not referring to any specific provision. However, given that most of the times the corporate debtors are banks and intermediaries, there are already existing provisions on how they should be how they should conduct their business, and there are certain code of conduct for them. It can be tailored to suit the needs of the IBC and CIRP process as well. What we are specifying is, given that there are multiple institutions which govern the creditors and also the CIRP process, it could result in multiple regulations. And also, like we have stated, that we don't want judicial scrutiny in the process, as a result of which we think the existing norms and regulations could be adjusted to be extended to the CIRP process as well.
So who should take action in case of violation of COC?
Right, that is the confusion that exists, and that's the lack, there does exist lack of clarity on that. However, we believe that given that judicial intervention is not the best way to go about it, that's why it shouldn't be made a hard law rather than like we should make it a non-mandatory soft law. However, we do not have the answer as to who should be the governing authority for the decision making of COC.
If
there is like a fairness part of it, or the partiality part of it, or lack of independence part of it, or something related to lack of transparency. Basically, the judicial aspect of it, maybe we can give it over to NCLT, but of course, something related to commercial aspect of it or business aspect of it is something that NCLT is not the correct body to do. So I think our answer would be that if it is something related to standards, like we have for independent directors when there is company and there is business judgment rule to protect their commercial wisdom, something similar at the stage of insolvency as well for the NCLT and by the NCLT for insolvency.
Yeah, so you have proposed a maximum haircut. So this issue has been discussed, I think, throughout yesterday and today. Right. So let me just sum it up for you. Right. So first of all, I think RBI Deputy Governor covered this. It was covered in today's newspapers also. This haircut is a discount which the market gives for dealing with the entity which has gone to the CRP process. So that is the first point. Second point was covered by MD SBI. So what you see as a haircut is not really haircut. It doesn't take into aspect various upsides which are there for the lenders. Third aspect is the denominator. How do you calculate the haircut? The realization by the claims. The denominator itself is flawed. Why it is flawed? Because the many times, especially the large cases, the account has ceased to earn any income for the financial creditor, much before the time CRP is initiated. But when CRP starts, all claims are calculated as on ICD and filed as claims with the IP. So you see the denominator itself is flawed. So that's why the ratio itself is flawed. And it's very important for us who are in the IBC ecosystem to be aware of this and create awareness of this so that we are not carried away by this media hype which is created on this haircut. Thank you.
Let me just maybe add something to that if I have a minute. So point well taken, and that's something maybe we'll keep in mind as well. But I think with regards to our paper, our focus was, given that the COC does have some sort of unfettered power in determining the haircut in some ways, we thought that there should be some regulations with regards to that. Maybe maximum limit is not the way to go about it. However, we have highlighted how the unfettered power does result in excessive haircuts at multiple times. I think that was the focus. Right. Yeah, that's right. Right. That makes sense. We'll take into consideration that. Yeah, thank you.
I have a very small point. When I came in, you were discussing about some sort of code of conduct for the insolvency professionals, and you presented that on the lines of the UK, we should also have some code of conduct. I think we have similar code of conduct of the impartiality, avoidance of maintaining confidentiality or maintaining transparency, keeping arm's length distance, taking reasonable fees. A whole bunch of code of conduct is given in our regulations, and they are regulated individuals today. So what kind of governance in an individual structure you are suggesting, and what kind of more code of conduct are you suggesting? You have any thought on that? Secondly, what kind of insolvency governance you are expecting from a committee of creditors in the sense of an independent director you mentioned? They cannot be as independent as the independent director is supposed to be. They have a very clear conflict of interest, and that will be a perennial thing. That will be there. That is the basis of the whole process. So how are you suggesting? Very, very, very theoretical and principle-based suggestions you have given. How it will work insolvency governance in the structure of that committee of creditors institution, where they are having a very, very inherent conflict. How can you avoid that? So any practical thought on that in your discussion?
So I agree that these are theoretical suggestions, and like you firstly asked that there are code of conduct for resolution professional, but I highlighted that The problem that exists is that the code is very silent on how would the court treat it when there's a breach of the code of conduct. And particularly one has to file an application with NCLT, and the entire process repeats itself again. So again, as throughout the conference it has been reiterated that time is of the essence. So we are actually looking for a code of conduct that would have a deterrence effect on RP. So one of the suggestion was to have a penal provision where the RP could be penalized, whether in terms of penalty or in terms of imprisonment, where he exercises his where he is partial, and there is inherent bias in the process.
And also, I would like to add that even in the present code of conduct, for instance, there are some lacunas. For instance, that at the moment, or even when the code was enacted, we have focused a lot on the independence from the corporate debtor, because we have sort of displaced them when the CIRP process starts. But the code of conduct is more silent on the need for RP's independence from even COC and its members. So that is one kind of example where we think there is some sort of lacuna in the code of conduct for the RP. That's number one. The second thing is that, thank you so much for raising the pertinent point that how can COC be compared with ID, independent director, because COC does have a vested interest because they are residual claimants at the end of the day. And this is something that I also mentioned or touched upon in the conclusion, that when we are thinking about something related to governance, it is something which is required to be explored, that to what extent we can compare maybe RP to independent director, but COC maybe to a non-independent director. So that is a sort of way forward for the query. Once we sort of acknowledge that there is a need for governance in the first place, and focusing on the how part of the process and not just the end result. Once we do that, to what extent we can take or import principles from the ID jurisprudence or the ED jurisprudence or the NED jurisprudence is something that we leave open for further discussion. Thank you.
This concludes the evening session. Thank you to the panelists as well as the audience, and to everyone who raised all those pertinent questions. Tea and coffee would be served outside, and the concluding session would be held at PP Gupta Auditorium itself.